It was so great to hear you speak on the panel today. You talked about how future cybersecurity laws should be written. Do you think that cybersecurity laws should be written with some flexibility to account for the rapidly evolving technology?
You really have to write the laws in that way because the technology changes so rapidly. If you're too specific, the law becomes obsolete before the ink is dry on it. When we wrote the Washington State data breach notification law, for example, we didn't try to define exactly when a breach occurs, but rather left it to the owner of the data to decide whether or not the hackers got far enough into the system to actually take data or see it. That was the right approach because of a very specific and technical definition of a breach would have become obsolete within a few years. So that's really the way to handle this kind of law drafting, as you go forward.
So I just heard you speak at the panel today on the sort of cybersecurity landscape when it comes to IP brand protection, GTLDs. And I had a follow-up question. How much money or how much of the budget should a company allocate to spending on IP brand protection?
I think the money that usually company has to spend is like, in my experience, I will divide it into like three parts. One part of it will be like to doing some non-contentious IP filing, including trademarks like copyrights and domain names. And then the one further, I think companies should be aware of is they should do some monitoring, brand protection, surveillance things to make sure that they know what's going on for competitors and also cyber squatters. And then the one third will be like for enforcement actions, no matter it's like arbitrations, litigations, cease and desist letters, that should be the one third.
So Alban, I thought you did a great job moderating the panel today. I had a follow-up question. With the new GTLDs, is it more difficult for a brand owner to protect its brand?
I would answer this question by just summarizing the panelists' perspective. We have a representative from ICANN, a registry, and also brand owners. From ICANN perspective, I think the answer is that they are not in the position to protect brands. They have an IP constituency, but their main aim is not to handle that part. So I would say that new GTLD is sort of not designed to be more protective for brands. From the registry perspective, I think a lot of the registry are actually launching their own protection mechanism to help brand owners. There are DPML, there are different types of protection mechanism that's sort of in the idea stage. We talk to a lot of different registry and they are all sort of thinking about that. But obviously, for them, it will be a commercial decision. They probably need to have some sort of return as well. From a brand owner perspective, that's the more interesting part. I say that Karen Law who used to work with Alibaba, her perspective is that it is a yes and no. It is a no because by applying for their own brand, they don't feel safer themselves. But they do think that they are more protected because of the TMCH and the DPML or the other different protection mechanism still in conception stage. So I think it is a mixed response. But I think it is certainly an improvement over the old sort of TLD structure.